My name's Lorena Saedi. I am the founder and managing attorney of Saedi Law Group, and I wanted to do this quick video about child support or alimony orders because it is something that comes up, not too terribly often, but it still comes up because bankruptcy and family law, we intersect a lot. So let's talk about these orders because I will have folks that file a Chapter 13 bankruptcy. This is when this is going to come up. They file a Chapter 13 bankruptcy, and part of the Chapter 13 bankruptcy is we're doing a budget, and we have to show what your monthly expenses are, and the trustees are going to want to see proof that you are making, if you have we call it domestic support obligation, if you are making a alimony or a child support payment, the trustee wants to see that those are being paid every month. Now, a frequent misconception about bankruptcy law is that we can modify your child support or alimony order. And nope, that is not the case. So what happens is someone will come in and they need to file and they're like, I can't afford it. I can't afford this payment. The child support, the alimony is killing me, which may be true, but bankruptcy court is not going to be the forum where you're going to take care of that issue. What bankruptcy court can do is we can take whatever you got behind on alimony or on child support. We can handle that. We can take that. We can put it into our little pot, our 60-month pot, and we can figure out a repayment plan. So that we can help you with all day long. And we help clients with that on a weekly basis. But I will have folks that start demanding that, oh, you need to file an objection to the child support, or no, I don't, because I don't do family law. I would not touch family law with a 100-foot pole. But you need to go to somebody that they do practice family law, or whoever you had in your family law case, and talk to them about doing a modification of the order. Because in bankruptcy court, everyone is going to go by what does the order say, the order that comes from state court. So if there is an order in state court that says you are supposed to pay X amount of dollars every month, then if you don't do that, then you will get bounced out of bankruptcy court. Plain and simple. And there's nothing we can do about it. And I know it might be unfair. I always hear that. You don't understand. I don't have the money to hire. I get it. But again, there's nothing that I can do for you in bankruptcy court because that is a state court issue. And that is something that has to be hammered out in state court. And I know it's not fun and I know it can be expensive, but you need to understand that. So sometimes people, when they come in for consult, I'll tell them that. And they're like, well, I can't afford it. Well, then you can't be in Chapter 13. A Chapter 13 is not going to help you because your case will not get confirmed if you are not making your monthly child support or alimony payment. I don't care how much you despise the other person, you gotta make it. And if you don't make it, then your case will get dismissed and then you're back to square one. So, my suggestion to folks is either wait and go back, a lot of the counties, at least here in Metro Atlanta, they have self-help clinics, things like that for people that are they don't have enough money for an attorney. They're trying to do things like modification. So, again, I don't practice family law, so I can't help you. And bankruptcy court is not going to entertain that either. So if you have a alimony or child support issue, you're going to need to get that taken care of first, or you're just going to have to suck it up. And while you're in the bankruptcy case, you're going to have to make that payment until you get it modified. Now, the good news is, you can file lawsuits against other parties. You can file modifications while you're in bankruptcy. You don't need permission from the bankruptcy court to go after for you to go after somebody. So you have that ability. So you can continue your fight, but until you win that fight and you have a piece of paper called a court order that says the child support has been reduced to a certain amount, then that's what you're going to have to pay. And especially, I have folks that have child support orders in other states, and it can get messy and it can get really, really confusing. I get it. I understand that. But you need to know what you're walking into if you're trying to file a Chapter 13, because you don't want to start a Chapter 13 case and, like I said, it blows up, you can't make the payments, and you're back to square one. So the bankruptcy really did nothing from you. I mean, it might have bought you some time if you're facing like a license suspension or maybe jail time because you haven't paid your support or your alimony. But it is an issue that needs to be addressed in the state court. So again, if you have alimony or child support arrears, bankruptcy, we can help you all day long. But if you're trying to modify a state court order, you got to go back to that state court and it has to be modified there. And then then it will be treated correctly in bankruptcy court. So if you have any questions about bankruptcy, at least here in the Northern District of Georgia, I'm always happy to answer questions. My information is below. I hope you found this video useful. And if you have any questions, again, don't hesitate to reach out.